Very good afternoon, and I'm also sorry, extremely sorry for for joining a little late. There was a little technical hitch, and
It's okay. It's okay. We understand all the technical issues.
Happening here also.
Don't be sorry.
shall we start or?
Yes. Actually, I had given your introduction while you were.
Okay. Thank you so much, Jyotiji.
Okay.
A very good afternoon to all the distinguished participants and to all the honorable judges and all the legal members and members of the legal fraternity. Well, after such an enriching session, the first session was such a eye-opener and such a lightning session that I hardly now think there's anything left to be that we can discuss. Still saying that now, as I have been asked to take a session on trafficking for forced labor, well, as all of us know that today, as in the first session it was discussed, and as all of us know that trafficking is one of the major means for exploitation of women and children, and that's the reason why we are here to discuss that thing. And how accountable is the support system, that is judiciary, police, and the rehabilitation mechanism, which are there in the rehabilitation mechanism, which are there, how strong and how strengthened they are while dealing with the victim of trafficking, especially from the forced labor. When we talk about forced labor, the trafficking, as I'm not going into a definition of trafficking because it's already been defined in the first session, and the types of offenses also it has been discussed. But when we talk about trafficking, in India, we see majorly there are about 4 different kinds of trafficking where women and children are most are impacted. One, that is for forced labor, that is child labor, commercial sexual exploitation, organ trafficking, and child pornography, child sexual abuse. Child marriage, of course, is another area where there has been a lot of trafficking that has been taking place, and especially in this pandemic time, we have seen that how the cases of trafficking for child marriage has increased. But these are the major 4-5 categories of trafficking that we see in our. But when I relate to the northeastern part of the country, especially in the Seven Sisters area, in the northeast area, there we see that the trafficking is mostly for commercial sexual exploitation, trafficking for drugs, trafficking for organ trading, and trafficking for pornography. These are the 4 major areas where the trafficking that takes place from northeastern areas of the country. Now, trafficking for commercial sexual exploitation is a forced trafficking, but at the same time, there are if I leave Meghalaya, Nagaland, that part, and if I come down towards Assam and little upper area, there the trafficking is mostly for domestic work, and of course commercial sexual exploitation. So basically, if we see that there are these 4 common factors which are there from the northeast for trafficking. One is for trafficking for commercial sexual exploitation, trafficking for domestic work, trafficking for child pornography, trafficking for drug abuse. So there are, and because it's an interstate border, like the northeastern part of our country have border with the neighboring countries. So many a times the women and children are utilized for selling and procuring of drugs from one side of the country to the other side. So these are the major 4 areas of trafficking that we see in the northeastern part of the country. Now coming down to the forced trafficking, or the forced labor that we are talking about, in the forced labor, there are majorly, as I said, we see trafficking for domestic work and trafficking for child labor. The reason why I'm talking about child labor, because, I'm talking more focusing on children, because 82% of the percentage of trafficking in one of the researches shows that that women and children are generally trafficked before the age of 18. So that is the reason why it becomes more important to talk in terms of children who are who are trafficked. And when I'm talking about children, doesn't mean that I'm leaving behind a woman, but the reason is because 82% of the victims who are trafficked are children. They're below the age of 18 years. And from 16 to 18, there are about 26% of the traffic victims are introduced into a commercial sexual exploitation area. Now, when I talk about below 18, that I would like to focus on the areas of trafficking where what are the different laws in our country that are there to protect, and what are the judgments that has come across to help and for the protection of these children. As I said, that 82% of the victims of trafficking are children. We have different laws in the country, and also our constitution has prohibited trafficking and banned. And trafficking, as I said, one of the heinous crime, and it is a violation of Article 21, 23, 39, 42, 46, 51. So all those violations takes place once there is a trafficking, whether irrespective it is for forced labor or whether it is for commercial sexual exploitation. Now, forced labor, when we talk about, now majorly I divide it into two categories, that is domestic work and child labor. When it comes to domestic work, it is a general concept that because we have an act called Child Labor and an Adolescent Act, so people in that act, it has been defined that child labor till the age of 14, and 14 above was an adolescent. So a general misconception when we deal with the cases, we see that if any child who's above the age of 14, it is presumed that the child is not a child, and he's an adolescent, so he or she can continue doing the work of domestic work. But the fact is, our country understands a child as the age of 18, which has been defined in JJ Act, and these children who are coming to work as domestic work, they are not coming out of their way. Even if they're coming out of their way, in the definition of trafficking, it has been defined that the consent is immaterial. So every child who's working as a domestic work, or every child who is working in the industries, are actually being brought by somebody from their source area, from their native area to a destination area. And generally, we have seen the destinations area are either the capital cities, or it is they land up in Delhi, Bombay, Calcutta, those areas. So the source areas are normally the areas from the villages, and the areas which are low economic region areas, the areas where there is more of poverty, and the areas where there is those aspirational districts of the country, where the economic productivity is quite low, and there's a lot of poverty in those areas, where the trafficker, actually a middleman who is there, they actually talk to the family, they convince the family, they lure the family, or they force the family to send their children to work, and to send the children outside to work, and so that they can earn money. But in actual sense, it happens the other way around. They send the children with the trafficker, they come, they work, but they never get what they have been promised. Because children cannot be used as laborer, because under the Act, the minimum age of employment is 18 years. So below 18, you are not supposed to be employed, because you will not get the minimum wage. So, but they traffic children because they're not supposed to get minimum wage to earn maximum profit. Normally, these children are being brought from the source area to the destination area and work as a child labor, or they are not paid the minimum wage, and they're made to work, as Mr. Vibhu said in the earlier presentation, that 9 hours, 10 hours. I'm not touching commercial sexual exploitation. I'll go to that after 15-20 minutes. But in child labor also, they are being made to work 9 hours, 10 hours, 12 hours continuously. We have rescued children where they are given, after the rescue, they have given the statement, the hours of work are really inhuman, and they work in a very inhuman conditions. So trafficking, it happens for the purpose again of maximizing the profit or earning the money. There's a middleman involved. Then the middleman comes and sells the first child to some other industry or to agent, a placement agent in Delhi, and that's how the give and take takes place. But the child doesn't receive anything in return. Children who are forced into labor, they don't receive anything in return, and they're treated as forced labor or bonded labor. Now we have a Bonded Labor Act to protect them. And under Bonded Labor Act, if a child is rescued, the child is supposed to, a child or any adult, Bonded Labor Act applies to both. And under that act, if a child or a woman or a male member who is rescued are supposed to get immediate compensation under the Central Secretariat scheme, and he's supposed to be also declared as bonded labor by the DM by releasing the release certificate. However, if we see the actual reality, it is not so the case. In Delhi, we have seen the DMs are very proactive in giving the release certificate under the Central Secretariat scheme, but the money takes a long time to come to the child. And it is, and as per the Bonded Labor Act, the DM is responsible for the ensuring rehabilitation protection to the forced labor or the bonded labor, and to also to conduct summary trial in time, but it doesn't happen in reality. In last 2 years, I have only seen 2 cases where summary trial has been initiated. And if you see under CRPC, the summary trial is supposed to conclude in 3 months' time. But in our country, in last scenario, it is only in Delhi, the state of Delhi, the summary trial has been initiated, and it's for last 6 months, it's still on and it's not concluded. So the challenge is, once, like if you don't conclude the trial, summary trial on time, you can't give compensation to the child. Because unless and until the trial is over, you can't prove the child is bonded, or child or the woman or the man who has been rescued is a bonded person. So the compensation part of it lies in the hand of the DM. So DM should ensure that the trial the summary trial should be concluded in 3 months' time, and the child gets at least 2 to 3 lakhs rupees, which can be used for his or her rehabilitation. Now, similarly, the thing goes in the when a child is rescued, there's also an FIR is lodged, as Mr. Raghu said. When there's a trafficking, there are multiple offenses are there. And in the definition of trafficking itself, it talks each aspect of the definition involves criminal proceedings. So whenever a child is rescued, or whenever a person is rescued from the bondage, and when we go to the police station to lodge an FIR, normally the FIRs are lodged under 370, because the child or the lady who has not come on a will. They must have been brought by somebody. So they have come from the source area to destination area with the help of some individual agent in between. So that we add 370 over there. At the same time, we also, the police also are supposed to add sections of JJ Act, section of STST Act. And in case of any sexual violence in any of the child, the sections of sexual abuse needs to be added. And at the same time, Bonded Labor Act. And when you add section 370, they are also entitled for under victim compensation scheme from SLSA. So the application can be moved to SLSA to give compensation under under victim compensation scheme for a victim being trafficked. Now, when I'm talking about victim compensation scheme, if I talk about trafficking and I talk about state of Meghalaya, the state of Meghalaya has a victim compensation scheme, but unfortunately, the state of Meghalaya and the victim compensation scheme only talks about giving victim compensation to victims of trafficking, provided there's a mental trauma or something. Now, when there's a case of trafficking, it is not about mental trauma. It's also a case about there may be physical injury. The child must have lost out school. The pace of, there may be other medical needs. So only dealing with the amount of 50,000, 25 to 50,000 for giving compensation to a victim of trafficking needs to be relooked. I would request the SLSA members who are here to work on it. There are states like Rajasthan, Delhi and other which have been quite progressive in this matter. The compensation amount they have quoted is about 3 lakhs. And also with that, if there are other offenses included, for example, POXO, if there is offenses like sexual assault, rape, those compensation will also be added, and the compensation to be given to the child. Now, recently, there has been an amendment in the POXO, and under that, there is a guideline that the compensation can be of 3 types. That is, one is immediate, second is interim, and the other one is final compensation. When we talk about immediate compensation, the amount can come from JJB. The CWC member can immediately release certain amount to meet the immediate medical need of the child. And also help in when the child has been rescued from a place and has been sent to a shelter home, the CWC is supposed to make an assessment report. And while repatriating also, CWC also has to make a rehabilitation plan. And in that rehabilitation plan, CWC has to ensure if the child goes back to the house, what will be sustainability mechanism, how the child is going to reintegrate back into society. Does the child needs any help or any financial help or not? In that case, the CWC will definitely link the child with the foster care thing, where the family gets 2,000 rupees per month under the ICPS scheme. So when we're talking about compensation, the immediate compensation can be given from the CWC, and then there's an interim compensation which is supposed to be released by SLSA. SLSA are supposed to release, and in the district, it is the District Legal Services Authority. And in case of a child or a victim of trafficking has not received any compensation, they can move a complaint to SLSA saying that they had applied in District Legal Services Authority and they have not got the compensation. But there's a time period for it, that is 90 days. Under 90 days, the child has to, the victim has to move an application before SLSA for granting the compensation, the interim compensation. And the final compensation is decided in the court. And accordingly, the court can give directions to SLSA to release the final compensation. Also, when we talk about final compensation, there's another way of extracting, giving compensation is by extracting fine by under JJ Act on the trafficker or the offender and giving that money to the victim. But that is a separate thing that we don't call it as in a compensation, but it is all, it's a fine that is collected from the accused. And once the court gives this judgment, it's a responsibility SLSA and CWC to ensure that a child gets that fine which has been collected under JJ Act and given to the victim. So one is the trafficking that happens, a child is or a woman is trafficked from a vulnerable area, from the source areas, and comes down to the destination area. And in the destination area, they are made to work in different segments. Generally, the industries, what we have seen them working are garment industry, automobile industry, bricklaying, and as domestic work. In all of those things, they are kept as bonded labor. That is why I talked about Bonded Labor Act and what the compensation under bonded labor, the relief under bonded labor. The relief under bonded labor is if when there is a rescue, immediately a statement has to be given before the magistrate. The magistrate has to issue a release certificate. As per the act, it has to be within 24 to 48 hours. And that is immediate under Central Secretariat scheme, that is 20,000 to be released immediately. And also to make an arrangement for the child to go back or the victim to go back to their place, native place. The DM with the help of Vigilance Committee will make an arrangement. And if it is required, the child for conduction of summary trial or for any medical emergency, anything, the victim needs to stay back in that city. The DM has to ensure and arrange the accommodation facility for the children or the victim under who has been rescued. Now, this we talked about once the rescue has happened. What is the procedure before rescue? If there are supposed to be Vigilance Committee, they are supposed to be informants of police. The moment they receive a complaint, immediately the police has to inform the DM and the labor inspector and the rescue operation. have seen the many times the NGOs, they go forward and they rescue, but they cannot do the rescue without the help of law enforcement agencies. They have to involve police, they have to involve the local district magistrate and the labor inspector for conduction of rescue operation. Now, as I said, the trafficking takes place for forced labor. That is why when there's a rescue operation and produced before the magistrate, before the police, it's very important that the section 370 to be added so that it is proof that a child is or the victim has been trafficked from some point to the destination area. And that doesn't stop there. That on the basis of the statement given by the child or the victim, further investigations to be done, and the statement needs to be recorded, and further offenses, which if the child narrates that I have been sexually assaulted or something, the police will immediately arrange for medical examination of the children and add the sections accordingly. So it also depends of like recently we had a case like there was information to an AHTU that a child from Jharkhand has been trafficked to Gujarat, and the AHTU team from Jharkhand came to Gujarat, visited Gujarat to rescue the child. While rescuing the child gave an information that there are other 16 more children who are located in some other premises. You please go and check them. On basis of her statement, the police went ahead, they rescued the other 16 girls and they brought them back. So when we talk about doing an investigation or doing a case, it's also very important to go through the statement of the child, what the child is saying. There was a rescue operation where from a domestic place we had rescued a child. Under relevant section, it was sections where appropriate sections were added, and the child was sent to a shelter home and was produced for CWC and sent to a shelter home. After 2 days, when the CWC members went to take the statement, the child narrated what all she had undergone over there, what all exploitation she had undergone over there, including sexual assault. Now, in the FIR, we just have 370 and we have Child Labor Act and Bonded Labor Act, but we had not included sections of POCSO. The CWC member, they wrote to the police, and on the basis of the statement of the child and on the basis of the letter of CWC, the police added the relevant section. Police again came into the statement of the child and they added the relevant section in the FIR. Now, if there is a case of POCSO, CWC can directly write to the police. But if it is not a case of POCSO and there are some other physical injury or some other thing that the victim narrates, in that case, the CWC has to write to the JJB magistrate, and JJB magistrate then has to give the direction to the police to add to the investigation and add the relevant sections. So this is a norm generally that has been followed for registering a case and investigation of a case. Now, in Delhi, we have something called Delhi, it's an order from High Court, and we have a Delhi abolition of child labor plan, where whenever there is a raid, the DM also comes down for the raid, so that they can seal the premises where the child or the victim has been kept bondage, or they've been working, or they've been employed. Without DM, the sealing cannot take place. The presence of DM is very important. Now, coming to this, the sealing is there in NHRC's SOP and trafficking SOP. But if I see in case of child labor, where the child has been trafficked and kept as a labor, the sealing of premises is not mentioned anywhere in the Act. But it is under the Delhi High Court directions, the sealing of premises are taking place. And that actually helps, and that is probably one of the reasons why we now today in Delhi we see the number of child labor has come down. Earlier, when we used to go for rescue operations, we used to rescue more than 80 or 90 children in any premises. Now it has come down to 15, sometimes 5, sometimes 10. So the sealing of premises has worked as a deterrence. And I think the magistrate who are dealing with the cases of child labor should also, in the state of Meghalaya, should also order for sealing of premises. And also not only sealing of premises, but as mentioned in the ITPA, the attachment of property, that should also happen, because that will create a deterrence message. Because the traffickers, we know, are very smart. They're looking for economic purpose at the cost of the vulnerable children and women. So in order to create a deterrence in the society, there needs to, the judges or the magistrates who are dealing with the cases should give order while to confiscate their property and conviction. And those judgments should be widely publicized so that it creates a fear on the mind of the trafficker. No matter however law we have, unless until we create a fear in the mind of trafficker, unless and until we increase the conviction rate, the trafficking will go on. We'll go on having forced labor, we'll go on having commercial sexual exploitation, and we will be exploiting our women and children in the country. So it's very important to give conviction which can cause deterrence. Secondly, it is also important that the conviction takes place on time. Under Child Labor Act, the conviction period is, I mean, it's a, we have seen that the conviction is taking a very long time, in spite of having witnesses and everything. The reason being, the cases are being tried in regular courts, and although it has been mentioned in the JJ Act, they should be tried in children's court, but it is not happening. In spite of having Section 370, it's a special act, still we are not been able to try the cases in the children's court. As a result, it takes long time to get conviction or any result in the case. So to have a speedy trial, it is very important, because we cannot be, unless until we have a trial on time, unless and until we have a judgment on time, you can't, I mean, how long will you be causing re-victimization to the child or the woman, because they have to come to court every time, every single time they're called to court for years together to depose or to wait for the hearing. And second, they are not being, I mean, there's a lot of trauma that is also involved. And at times so happens that they refuse to come to the court if there's a very long delay or a long trial take place. So the idea, especially if children are involved, it is better that if we finish the case on time, so the child, his or her education is also not affected, and the child is properly rehabilitated and reintegrated back into the society. And a deterrence message is also created in the mind of trafficker that if I do traffic children, then I will be behind the bars. And in villages, we have seen it's a very, as Mr. Ribu said, it's a very complex crime. There are a lot of people involved into it. Recently, during the COVID period, we got an information that the moment there was a relaxation of lockdown, earlier it used to happen that a trafficker used to get the children from village and come to the place of work. But now what has happened, in the destination area, the industries which were running and who were employing child labor, they are sending the vehicles to the village to get those children to work for them. Now, we got this information, and we have, in this lockdown period, we managed to rescue about 281 children from the clutches of trafficker, and from the and save them from getting forced, save them from the forced labor. So it is, and this trafficking happens, when the trafficking happens, and if anybody feels or wants to complain, they can complain either in the source area or transit or in the destination area. There have been a good lot judgment on this, where the trafficker, where the child or the victim wants to lodge a complaint, can lodge. Now, when we're talking about, again, in terms of forced labor trafficking, we have also seen police has become very proactive. They take actions, they add relevant sections and all that. But once it comes for the trial, it takes a very long time. I have already told the long delays do hamper the growth of the child or hamper the case in long run, because the child refuses to come forward to come and depose, because one, they have been rescued from a destination area, and once they go back to the source area, it's very difficult for them to commute. And fortunately, our court has recognized this problem. They've allowed video conferencing. So this process of giving testimony or giving evidence to video conferencing has been allowed by the court, by the Supreme Court and other apex court. But I have not really seen any the Metropolitan Magistrate or the Session Court really taking up or using this mechanism for taking the evidence of the child or the victim who has been repatriated to his or her place. That's a gap that which we need to, all of us needs to understand, that it is very difficult for a child or a victim to come every time to a city or every time to the destination area where the case is on to come and depose. So it will make a lot easier if the statement or the thing can be done through video conferencing. Other thing, what I have seen many a times, that 164 statement is not recorded once the child is rescued. That's a big challenge. Now your whole statement is based on it, whole case trial is based on it. But because there is always a hurry to repatriate the children, that people forget to record the statement. And then again, there's a long delay, charges are not filed on time. In Delhi, I mean, in one of our case, we got this order of filing the charge sheet within 45 days. But in spite of having this order, the charge sheet are not being filed on time. Even the normal due course, which is 3 months, that is also not being followed. The reason being, because once a child is rescued, CWC takes the statement and the child is repatriated. There is no recording of statement. And if there is no recording of the statement, the police also delays the investigation process. As a result, the charges are filed late. Magistrate can always ask and call the police once they file a charge sheet. They can ask a reason to the police why there was a delay in filing the charge sheet. There is a provision under CRPC under which the magistrate has a right to ask the police for giving an explanation for delay in charge sheet. And in case if there has 164 statement has taken place and whatever the element the child has said in an investigation, those are not there, the magistrate has a liberty to ask the police to do further investigation and file the charge sheet again. So magistrate has that provision under CRPC, and I request all the magistrates who are dealing with this to exercise this power and see the charge sheet is foolproof, so that we get conviction on proper, so that the case leads to conviction. Many a times during the conviction, what happens, in the course of trial, what happens, important witnesses are not called forward, or even if they call, they don't come forward. The reason being, there's a lack of victim and witness protection for the witness to come forward to depose. In trafficking case, as it was said, that it is a case where the trafficker are always on, the motive of the trafficking is to exploit children and earn maximum profit. So nobody wants to go behind the bars. So what their tactics would be to pull down the witnesses, not allow the witnesses, give threat to the witness, and so that they don't come forward to the court to depose. And probably that was one of the reasons why it was decided that even it was allowed that the victim can depose through video conferencing. There should be a separate entry for accused and the victim. In fact, to the extent the cases where there is POCSO involved, in those cases, at least we can take up and we can follow the special code which has been made for the children, child friendly, where the accused and the victim, they don't see each other, and they can depose very comfortably. I would like to narrate an incident over here. I was dealing with a trafficking case where a child was trafficked and was rescued in Delhi, and the child was 14 years old. And here the trafficker was a woman who had trafficked her from Assam. Now, when she was trafficked, when she went for the statement to depose for the magistrate, she was taken to the court. Before going to the door, she was conscious, she was okay, and she was willing to depose and all that. But the moment she went there, she refused to talk. She refused to talk. All of a sudden, she changed, and we did not understand why that happened. Then once she was out of the court, she told us that agar main bolti, if I would have said, my photograph would have been there in the newspaper and my family member would have come to know about it. Now, what is this? Why did she say that? The traffickers are very smart. The accused himself was not present, but one relative of the accused was moving around in the court, and he had a newspaper in his hand, and there was a picture in the newspaper, and he just pointed to that newspaper, pointed to the picture in the newspaper, saying that he did not say anything. He just pointed his finger to the picture, and that was enough to put off the victim, to scare her, and she did not depose before the court. She said, "Agar main bolungi to mera picture aa jayega. If I say, my family member will come to know, I'll be all over the place." So maintaining confidentiality and protecting victim and the witnesses is also responsibility of the court. So when the judiciary, when they're dealing with children and women, especially who are victims of trafficking, they have to be very, very careful and ensure that the victim and the children are protected. And there is a scheme called Whitney Witness Protection Scheme, under which if any victim or a witness who are getting threat, they can lodge a complaint, and they will be given protection under that. And thankfully, the state of Meghalaya, the High Court had ordered in 2018 extensive victim protection guideline, which is a wonderful guideline which the High Court of Meghalaya had ordered. And in that case, it not only talks about giving protection to the victim, it also talks about engaging support person to go and talk to the victim before coming to the court, talk and give them a counseling, and also telling them about the court atmosphere, giving an exposure visit, and the support person also, if required, his or her witnesses to be taken. So those are the guidelines which Meghalaya High Court had issued in the year 2018, and those are very good guidelines. And if that can be put into practice, it will be a great help, and not only to the victim and the witness, but also to the judiciary, because the trial will get over on time and it will lead to conviction. So this was about the children who were, children who were trafficked for forced labor from different parts of the country. But one thing that we forget, that while repatriation, they are supposed to be given certain, the CWC is supposed to make an assessment and develop a plan for rehabilitation plan for the children. But unfortunately, in practice, it is there in the act, it is there in the law, but in practice, it is not happening. So the CWC member who are there, please ensure that there's a proper rehabilitation plan. And you also share the information with AHTU, because anti-human trafficking units are there to rescue and stop children from getting trafficked. So share the children who are vulnerable and who are being repatriated, so that there's a vigilance that is kept on them, they are not re-trafficked, and the proper rehabilitation schemes are there so that they get benefit out of it, and they are not re-trafficked, or they are not pushed into the labor once again. There were cases filed in different high courts, and there was one case where there was MC Mehta judgment, where it was said that because the government, the judiciary had recognized that if property is one of the case, and if the child is not given any kind of compensation or rehabilitation, it's very difficult for the child to reintegrate back. So under that, they have a MC Mehta scheme, under which they're supposed to give 25,000 to the child, 5,000 from the 20,000 for the labor department will give, government, the employer will give, and 5,000 from the government will come. So it's 25,000 to be collected. And to be, there's under the Child Labor Act, there is a fund called Child Labor Welfare Fund, and it needs to be, it should go into a Child Labor Welfare Fund, and the interest of the fund will go to the child till the child attains the age of 18 years. Apart from that, the court has also given order of recovering back wages, which the labor inspector is supposed to do, recover the back wages and give the money to the child. And recovering the back wages is also not only the role of labor inspector, even CWC can also recover, summon the employer and recover the back wages as per the minimum wage of the state where the child has been rescued. So that helps, that financial help actually helps the family to overcome the problem for which they had moved to city by a false promise by the middleman. So once the child gets those money, if the MC Mehta fine is recovered, if the employer fine is recovered, if the final conviction order and that money is given, CWC gives immediate fund under the JJ Act, and then under CLPR and Bonded Labor Act, under Bonded Labor Act, under the Central Secretary scheme, if the child gets money, it is easy for the child to be rehabilitated, and it prevents them from getting re-trafficked. So this was for the trafficking for forced labor. Now there's another form of forced labor, that is commercial sexual exploitation. Nowadays, when we talk about commercial sexual exploitation, it has taken many forms. I'm not saying it was not there earlier, but during this lockdown period, it has increased almost 95%. In fact, there was a study recently by an organization called India Child Protection Fund. They had brought out a study, a research on child pornography. Children who have been trafficked for child pornography, and the demand for child pornography had gone up, increased to 95%. So imagine the kind of exploitation a child goes through, even when there's a lockdown and the whole country is not moving, but the children are forced to undergo this. So it's another aspect of commercial sexual exploitation, because the money is earned from there and child is sexually exploited. And this is done through various means. Either we have now got this thing, we have all the social media side like Facebook and WhatsApp group where you get friend requests. The children are vulnerable, but actually it's a trap that the girls and the children belonging to a vulnerable family who falls into the trap, and they're then exploited. They're made to do certain act online, and which are being recorded via the hidden camera, and they're not aware of it. And it's again a cybercrime. So this child pornography has been addressed in POCSO, and which attracts a severe penalty under this. And it has been a major issue in the lockdown period. And it's not only that the children are willing, they're themselves doing it, but they are also being trafficked from different places to do this. And generally, it has been seen that the family belonging to the lower income group, they are being targeted, and children from those groups are being taken, and they're being asked to take nude photographs, do sexual acts and all that over the camera, which has been recorded for and for payment of against some payment. Now this has become a major problem. Now once the police take this, it is also important that not only the trafficking and child pornography under POCSO, but also IT Act also needs to be a part of this, because it's an offense under the cyber law. So the IT Act also has to be a part of it. The IPC should be there, and because the traffic 370 has to be there, because it's child pornography, the sections of POCSO, relevant section of POCSO has to be there. Now, this trend of increasing of child pornography doesn't mean that children are not getting trafficked for physical exploitation. Children are also getting trafficked for commercial sexual exploitation. And we see that there are laws like ITPA, there are laws like IPC, then the POCSO, wherever POCSO is required. But there is not a single comprehensive law which deals with protection, prevention, rehabilitation of the trafficked victim. As I said, before the age of 18, the maximum number of children who have been pushed into commercial sexual exploitation are about 82%, and 26% are before the age of 60. So there is we have in bits and pieces the laws and provisions. For example, we have laws like there has to be after NHRC's research, NHRC found out that there's no protection. There's no protection of women and children, and children, women and children getting trafficked. As a result, they created an anti-human trafficking unit. AHTs were created. And during this lockdown period, we had filed a petition in Supreme Court where one of the prayer was to set up anti-human trafficking units all across the country. And in the month of July, the Ministry of Home Affairs came out with a directive that the anti-human trafficking unit has to be set up all across the country. And also fund from Nirbhaya fund was allocated for creating this anti-human trafficking unit across the country. Now, the role of anti-human trafficking unit becomes very important because when a child is trafficked, it's not only it goes to different areas. It goes from source to transit to destination. So there are 3 areas that are involved. So if the anti-human trafficking unit is informed, or if a child goes missing, immediately the data is shared with the anti-human trafficking unit. They will track the child, they will rescue the child, whether it is in transit, whether in the destination, or within the source area. They're supposed to conduct vigilance in the source area. They're supposed to rescue the children once if they come to know about it. And the Ministry for Home Affairs has recently also talked about placing a migration registry at the panchayat level. Now, this is a very important concept because we have seen children going missing and children being brought on to a destination area on false promises. So if anybody is moving out from the city and if they register in the migrant register and the data is shared with AHT, if the panchayat shares that with the AHT will be able to track those child and save the children or the victim. It is not only for children, it is also for women and men, because men are also being also get trafficked. So they can be tracked and they can be reintegrated back to, they can be rescued and reintegrated back to the society. So it's important that AHT should be established at all the places as per the directions and directive given by MHA. And every police should in each district, especially in the northeastern states, should have active AHTs, because we have seen the maximum time the children who are, or the women who are trafficked or commercial sexual exploitations are from the northeastern areas. So AH2 has to be very active, and they should coordinate with different AH2 across the state. They should share the information immediately if a child goes missing. Once the police registers the case, in the JJ Act, it's mentioned that's 3 months, but now there have been recent judgments by Delhi High Court and Madras High Court, which says that within 24 hours, because 3 months is a too long time for a trafficker to take the child to an unknown destination and exploit the child. So within 24 hours, if a child goes missing, the case to be transferred to AH2, and AH2 can then again, the case can be given to AH2 for further investigation and to rescue the girl. And this has proved quite effective. And AH2 has been successfully, wherever they have been given the cases of this kind of thing, they have been able to rescue children. When it comes to commercial exploitation, we all know what ITPA is. We all know what the major act is ITPA. But we all know that most of the time, it is the victim who's being picked up by the police, not the pimp, not the accused, not the customer who visits them. In case of children, it is must that the customer should also be arrested. Because if you go by the definition, one who hires for any illegal activity is also a trafficker. So here the customer buys or gives the money to the pimp to have the child or the victim for sexual exploitation. And whether the consent of the girl is there or that is immaterial, because trafficking talks about this thing that the consent is immaterial. So in case of children, it is practically not possible to accept the consent, because that is the direction of the court and direction of the JJ Act. So consent is immaterial, whether there's a consent. And most of the time it so happens the accused and the pimp and all, they say, and they are normally they get bail and things like that, because they say that wo apne marji se aayi thi, she has come on her own, she has given a consent. But that is, the consent should not be accepted, and it is instead of the girl, it is the trafficker or it is a pimp owner who should be considered as a trafficker, and the customer to be arrested under 5(1) of ITPA Act. Now, when we're talking about ITPA, the ITPA talks about provision of a special officer and who are supposed to conduct raid. They can visit the brothels, they can conduct raid, and they can rescue the children. children and women on the exploitative condition. Once they are rescued, they are supposed to be brought before the magistrate. Now, magistrate is supposed to take the statement of the child or the victim and accordingly decide what support the child needs. The magistrate can always order for a panel of 5 members where 3 can be women, and to support the magistrate in taking the decision. The magistrate can order that there should be support person to given to this child. So child should be counseled. Magistrate can decide to take the statement that day, or can wait till the child is counseled or the victim is counseled, and accordingly take the statement. The magistrate can also has a right to ask police to do further investigation the case in case the magistrate is not satisfied with the investigation that has been done by the police in cases of ITPA. In cases of trafficking, there is once there is a rescue, the brothel from the brothel or from any place where the prostitution is on, or the children after the rescue or the victim of the rescue need to go for medical examination. But there is again a problem over here, the challenge that is there. Many a time, women refuse to go for medical examination. And also, I mean, if a girl who's about 15, 16 years, they generally refuse to go for medical examination. One cannot force them to go for medical examination because all the ITPA talks about medical examination, but one cannot force them because there is a guideline by the ministry. It's the woman has, the child who is not comfortable, you cannot force them for asking them to go for medical examination. Similarly, you also cannot force them, for any woman or child who have been rescued from the brothel or any exploitative place, you cannot also force them to go for HIV test. And in case if they have gone for HIV test, their report and other thing has to be kept confidential. So that is one thing that the magistrate needs to ensure that the child is not forced to go for medical examination for HIV. And in case if they're gone for HIV test, the confidentiality has to be protected. It is also where many a times I've seen once the victim is picked up during the rescue operation, there are also children of who are there, children of the victim, and they are picked up and they are separated. But there are many guidelines in Vishal Jain and others. It has said that the children cannot be separated from their mother, and they have to be kept with the mother. They cannot be separated from the mother. And the magistrate who is taking the statement has to ensure the proper provision is provided where the child is with the mother and the protection is given to the mother as well as to the child. So this is the I mean, this we talk about when victim is generally picked up by the police. There's other thing which comes into a thing where police, of course, after a lot of sensitization has also changed their attitude, and they have to the victim, as I said in when somebody is forced into labor or when somebody is rescued while taking the statement, in case of commercial sexual exploitation also, the police needs to have proper conversation with the child to understand who all are involved. A proper conversation with the victim who has been rescued to understand who all were involved in the process and how she landed up here. And they should enter the names of the people in the FIR from the time that she was picked up, how she came, who all were there, and who all were involved, and who pushed her over here. All the names has to be mentioned, and they all need to be arrested. Now there's a judgment by court, because many a times we have seen once you rescue a lady or a child from a brothel, immediately many people come down as a relative. It is one case, trafficking is one case where people come forward and say, I'm the relative of so-and-so victim, I'm relative of this girl, that boy, I'm chacha, I'm father, I'm brother, I'm sister. You will find so many mothers also. And you will find lawyers, a same lawyer representing both the victim as well as the accused. because most of the time when once you rescue a lady from a brothel, the brothel owner are women. Many a times seen. So the accused is also a woman, the victim is also a woman. So what they do, they have, there's one lawyer who will be looking into the case. Now, in case Prerna versus State of Mumbai, in that case, it was decided that the same lawyer cannot represent the victim as well as the accused. And if there are 5 accused, there has to be different lawyer also. The same lawyer can represent the case. Now, that is a challenge actually. Although it's a very good judgment, but we have seen that in practical reality, and judges who are dealing with this have to be very, very cautious. In practical reality, what happens? From the same law firm, the senior will represent accused and the junior will represent the victim. So this is a challenge, and the lawyer, the judges who are dealing with it has to be very careful and ensure that that the same lawyer is not representing the victim as well as the accused. The other thing that happens many a times when the child is handed over to CWC, in case the victim is a child, they are handed over to CWC, and a lot of representation is made before the CWC. Well, under this direction, it is a clear mandate that no representation to be made before CWC in case of trafficking. No lawyer will go and represent that I am from the victim side, I want this, I am giving you this order, or I'm filing this application, please consider. So no representation will be made under this judgment. So it is because the court wants to, the judiciary wants to protect the children and the victim who have been sheltered to shelter home also, protection home also. Those are adult victims. So representation of lawyers before CWC is has been discarded by the court, and there's a strong judgment that lawyers cannot make a representation before CWC for in the case of trafficking victim. Till the time the trial is on. Now, many a times we have also seen one of the other challenge from the victim side. What I have seen that because there is a case going on after the rescue operation, the victim is not allowed to go back home. The victim is made to stay in the protection home or in the shelter home in case of children. In case of children. Now that is against the basic right of the victim. We are actually restricting the freedom movement of the victim and the child, and this was challenged, and there are ample number of judgments which says that are allowed to go. In fact, one case where Delhi High Court had taken cognizance of this and had come and given a direction. The victim should be allowed to go, and the statement to be recorded through video conferencing. So there is now, there is no point in keeping a victim in the shelter home for a very long time, only on the pretext that the trial is on. So the magistrates and judges who are dealing with when they come before you to take a statement, please ensure that the child or the victim who is in the shelter home doesn't stay in the protection home and is repatriated to her family. If she wants to go, she's repatriated, and her video conferencing, her statement can be recorded through video conferencing, and the local police needs to be informed about it, that the girl has been repatriated and her trial is on, and whenever there's a requirement, her statement to be recorded through video conferencing, or if she can come down as well. But this judgment also doesn't negate the thing that if the child needs protection, then the child also CWC can ensure the child stays in the protection home. Similarly, in case of adult, they can stay in the protection home. If there is a requirement of protection, or if there is assumption that if the child or the victim goes back to the village, he or she will get re-trafficked or get influenced by the accused. In that case, CWC has the full authority not to allow the child to go, but to keep the child in the shelter home and plan a proper rehabilitation in the shelter home itself. And many a times so happens that even the victims who have been rescued, they are not willing to go back to their own places. Reason being, as I said, trafficking, And commercial sexual exploitation is attached with a lot of taboo, especially if you are working in a labor condition. You're rescued, you go back home, nobody will talk about it. But if you're working, if you have been rescued from a brothel, or if you have been sold for commercial sexual exploitation work, and once you go back, normally the society, we have seen victims are not accepted. So they don't want to go. But in that case, a proper rehabilitation has to be planned. Magistrate, while taking the statement, the victim can always ask the magistrate what she wants, and that can be arranged. If it's feasible, that can be arranged. How she wants to be rehabilitated. So that can that aspect can be looked after, and that help can be extended. Now we're talking about commercial exploitation. It is again, I would appeal to SLSA, as I had said in the first, compensation for trafficking victim to be enhanced, because a child or a victim who has been rescued from commercial sexual exploitation situation, brothels and other areas, has a lot of medical problem, and they need to be given proper medical facility. The compensation needs to be, amount needs to be high. They also, in most of the ITPA cases, I have seen that they don't go for Bonded Labor Act, whereas they have been kept as a bonded labor. The magistrate who are dealing with it, please ensure that you also direct the police to add bonded labor section and take the statement, and also issue release certificate and give them the immediate relief of 20,000 rupees. And if you, the metropolitan magistrate can, so the district magistrate can refer the case to district magistrate, and the district magistrate can do the summary trial, and on completion of the trial, they can give 3 lakhs amount, which is once you're proved, once you're convicted, the fine is 3 lakhs. So if the summary trial is over, DM is convinced, and this girl was brought and kept in a bonded condition, because brothels and all are in a very bad condition. They are made to do sex 9 to 12 hours. They're drugged. They live in a very unhygienic conditions. They're not allowed to go out. All those are the aspects of bonded labor. So the bonded labor section needs to be added when we talk about ITPA, and the judges who are dealing. In case police has not done it, you have the mandate, you have the power. Please direct the police person and to refer them to district magistrate to add bonded labor section. Also, when the district magistrate is taking, because once the child is rescued, first goes to the district magistrate. When they are taking the statement, they can also by themselves initiate this and add bonded labor section and give relief under the bonded labor act to the child. Once the bonded labor section is there, the child gets relief under the bonded labor section, and simultaneously the criminal trial will go on in the court. And if required, there are cases, there are judgment where, because after the rescue, it is the child is produced with a DM, and many a times DM also has been a part of the rescue operation. So if required to prove conviction in the case, the trial magistrate can always summon the DM to come before and depose as a witness. So there are cases which has happened. There are judgments where and it is there a mandate under CRPC where the magistrate, the DM, the one who was part of the rescue operation, the one who had taken the statement initially, are called to the court to depose and held the court for held the case in the trial. So calling DM is for many, but many a times generally it is not being done. People don't do it, but there is a provision. So please make utilize of it, because end of the day we all are here for to stop trafficking. We can only stop now by creating by creating deterrence, and deterrence can come by conviction. So the DM should. The DM, if required, DM need to be called to the court for giving the witness, and that will strengthen the case actually. So that is the other thing. What many a times we have so seen that trafficker in a commercial sexual exploitation case, they get bail very easily. Now they are not but the magistrate, while giving the bail, should ensure that, because when commercial sexual exploitation thing is there, especially if the victim happens to be a child, you also have POXO attached to it. So they, and in POXO, bail is and trafficking is also an cognizable offense, and POXO, the bail is more, not to be given to the offender. But in trafficking cases, we have seen that majority of that time the bail is given, and after that they abscond. They just go away. And then they try to influence the victim from somewhere else, and again the victim is re-trafficked, and the victim is threatened, and the victim family members are threatened. So there are court judgments. In fact, there was a trial court which had denied bail to the offender, and the offender went to the High Court, and the High Court gave bail, and that was again challenged in the Supreme Court. In fact, this case was bail in the sense that when the rescue operation happened and the victim gave the name of the accused who were involved, the name of the pimp, the name of the brothel owner, and who brought them. And when police went for them, they went for anticipatory bail. And the trial court denied. The accused, they went to High Court. High Court gave the bail, but Supreme Court denied. And Supreme Court denied on the ground that it's one of the heinous crime, and if the bail is given and the onus lies on them, they have to prove that they are innocent. And in this case, the girl was a minor, and they have to, and POXO was attached to it, and the girl, they have to prove that they are innocent, and irrespective whether she's minor or not, but they have trafficked her. It's a duty of the police to investigate, and on that ground they denied the bail. So bail was the anticipatory bail. Many a times I have seen, I have handled trafficking cases. Anticipatory bail is many a times given by the magistrate. So please do ensure that that doesn't happen. There is an effective Supreme Court judgment on it. So kindly don't give bail, anticipatory bail to the. And while giving bail also, one should ensure that if the person goes out on bail, doesn't harass the victim, will not impact the case adversely. All these conditions one is to see, and this has been given recently in 2018. There was a case, the Freedom, there was a placement against name by Freedom versus State of Delhi, and in that this order was given that while giving bail, one should ensure that it doesn't affect adversely the case. It doesn't, the accused doesn't threaten the victim, and doesn't leave the place. In case of violation, then the bail has to be cancelled. So these are the bail provision. While giving the bail, one should ensure that the bail, that accused doesn't get bail, and the bail is cancelled within the proper time frame. And yes, one more thing: if somebody applies for bail, the prosecutor has to be informed. 15 days notice has to be given, and there has to be representation from the victim side also. If there is no representation from the victim side, and the prosecutor has not been given time, the public prosecutor, then the bail cannot be granted to the accused. These are the recent guidelines, and which one needs to follow by, one needs to keep in mind while granting bail. So it's very important that some representation from the victim has to be there while granting bail. If there's no representation, the court cannot grant bail to the accused. But many a time so happens because victims, the offenders are women, especially in commercial sexual exploitation cases. So they have given bail. Actually, there was recently a case where 3 girls were rescued. One was 28, one was 18, one was 16. Initially, when they were rescued as victim. But during the statement, the magistrate realized, the statement when the district magistrate for whom these girls were produced, he realized that the one who is 28 is actually a trafficker. And he directed police to do further investigation. And she was also booked as an offender, and the case also was initiated against her. She used to get girls from Assam and Meghalaya for prostitution in Delhi. So she was again booked under the section. So the magistrate, while taking the statement, the role of magistrate is very, very important. please do ensure that whatever the victim says in a very child-friendly or very good, in a friendly atmosphere, so that you can hear the right thing and the truth from her, and accordingly take the judgment. And when the charge sheet is filed, we go through the charge sheet. If the charge sheet is incomplete, you can always summon the police. You can also call up the police to rework and do further investigation and file the charge sheet if you are not satisfied. And also to file timely charge sheet, you can also summon the police to file timely charge sheet in the case. Now, coming to this, as we don't have any rehabilitation mechanism in the country, it depends a lot on judiciary while giving the final order during the trial in commercial sexual exploitation to give directions for some order in terms of rehabilitation. There is no standard rehabilitation mechanism in the country for victims of trafficking. Everybody has their own thing. Of course, in Vishal Jain and others, it was said that there should be a rehabilitation, victim should be rehabilitated and all this thing. Justice the Kamaka committee also had talked about rehabilitation, the government should come up with a scheme, but there is actually, if you see, like supposing if a victim is rescued, the trial is on, the child victim is repatriated, what if the family is not accepting, then what? What kind of rehabilitation are you planning? How do you plan to reintegrate her? What are the steps so that she is not re-trafficked? So while passing the final judgment, it's my request to all of the judges who are sitting here, at least you can ensure, give a direction, the ASU to keep a track on the child and keep a vigilance on the child or the victim, the female or the male victim who are the adult victim, that they are not re-trafficked or they are not re-pushed into the conditions. They can also, even the court can give orders for the education of the child. They can be enrolled in the, under economic weaker section category in different good schools. Why only government school? Different good schools. The court can order for the relocation. Court can order for compensation for the relocation, because it's a very important aspect of dealing with victims of sexual assault, to rehabilitate them. If we don't rehabilitate them, there is no point in rescuing them, because they will come back to the same situation again. So it is very important that the victims are properly rehabilitated, and judiciary can, because as we don't have a standard norm for it, judiciary, while passing the orders, can make those recommendations in the orders, can give those directions in the order. The children can be enrolled in the schools. They can give orders for relocation. They can give orders for age, keep a vigilance on them.
Can you please, Mr. Ripinar, can you please mute your mic? Okay, it's done. It's done.
Also, as we see, it's like it was a little confusing. It's not so clear. Many times victims are also picked up and other who are also offender. Those offender may be the first time offender, and there is a provision called personal bond, where the offender can discuss with the magistrate, and the magistrate is satisfied, can release her on a personal bond where she doesn't have to pay money. And this provision is there in the CRPC also. So, and there is a judgment also in relation to this. The first time offenders can also be released under a personal bond. And but if they are again repeated offender, then they should not be getting bail. They should not be released under the personal bond again. So the personal bond is very specific, only there for first time offenders, women, and generally it is I mean, a little lenient towards women, and because you can't keep a woman, I mean, if she wants, and she can have a direction, she can have a dialogue with the magistrate, she can give a statement to a magistrate, and the magistrate is satisfied with her statement, and she can release her on a personal bond, for which she doesn't require money. You don't have to give a surety over that. So that provision is also existing under the law, and it has been upheld by the Supreme Court also. Now, if there's any question, I would like to take questions.
Yes. If there are any questions, please put them in the chat box, because I think Ms. Behura has covered all the points that were necessary for the sessions in very detail, and she has also highlighted the important judgments that further clarify the provisions in law and the relevance of the provisions in law that must be used. So if there are any questions, we'll be happy to take those. There are no questions here. There's just thank you.
But let me see, Miss Jyoti. Let me ask.
Yes.
Maybe it's Master Per Bax Marwin. If you have any question, do you have any question? Okay. Otherwise, I would have expected some questions from the.
Okay, then do I have the liberty to ask question?
Yes.
Okay. Whether for forced labor or whether for commercial sexual exploitation, whenever there is a case and whenever there is a doubt on the age, what do you do, sir?
I would like to bring to your information. We have very less number of cases here in the Meghalaya, like reported, I mean, and very few cases charge sheeted. And it seemed the trial of the cases also has not, some have, I feel, from what I could hear, I came across from, I learned from the officers that they have come across only one case where it has proceeded for trial. So lack of experience from their side also in terms of the cases. So regarding bonded labor, I don't think any case is there in Meghalaya. From the police, AHTU, can you answer this? Is there any cases?
My question is a simple question. It's irrespective of bonded labor, irrespective of child labor, irrespective of trafficking. My question is, if we have rescued somebody, there's an accused as a victim, and in case of doubt, what do you do? Doubt regarding their age.
So there is a response in the chat box which says that JJ Act provisions will be followed in cases of children below 18 years.
What if the child is 18? Or 17, and the JJ Act provision says that your school certificate or birth certificate, in case of absence of this two, then bone ossification test. Now, bone ossification test is +2 -2. It will come result as +2 -2. How do you go for? How do you decide that the victim or the accused is a child? Because the whole trial will depend on the age factor. If the accused is a child, it will go to JJB. If the accused is a major, it will go to the session court or the trial court. And if the victim is a minor, then you will have relevant section of POXO and other thing. And if victim is a major, then you will have, in trafficking, you will have rape and other sections.
Yeah, for that recent ordinance regarding the POXO Act, those who have attained age of 16, then they can be taken into children court. But apart from
what
that,
is children court?
Children court, those the cases where the accused have attained the age of 16 years. They will send, but then yes.
In all cases where the the child has attained.
No. First of all, the principal judicial magistrate, along with the members, they'll have to do that. They'll have to do that test as per section 15 or 16.
Okay, ma'am. Now I would like to clarify
they'll have to get this what do you say, they have to send the accused to the what do you call, psychiatrist. They'll have to do that test and to find out the capability of understanding.
Ma'am, the provision says, if I go by JJ Act, which was amended in 2000, a new act was brought in 2015. It is not an amended act, it's a new act altogether. Under that, there was this provision, which earlier it used to be, say, till 18. But when this crime happened, the Nirbhaya crime happened, one of the boy was a minor. And it was decided in this act, it is written in this act, for any heinous crime, if it is done by a boy aged between 16 to 18, it will first come to JJB. JJB needs to make an assessment based on the police report. Yes. Whether the child has done in the mind, with an innocent mind, does he know the consequences or not, or he has done everything in a very mature way or in a matured mind. Based on that, the matter will be referred to children court, which is nothing but a child court for a child-friendly atmosphere. In case of trafficking, we have seen children are also part of, part of, what do I call,
it's a group of adults. It's a group of adults in
groups of adults who are involved. Children are basically used by the traffickers to ferry the girls from or the children from one place to other place and push them into the. They are used as a medium. So once they're used as a medium, they are also offender. So when we're talking about offender, and when we have a doubt regarding the age, whether the child is a major or a minor or comes between the 15 to 18 wala category, in that case, one has to follow the JJ provision which talks about school certificate, birth certificate. Now we have a case in Delhi, we handle a case, state versus Manoj versus state of Delhi and NCT. In that case, what had happened, the boy got bail because if you are a minor, irrespective of the age of 15 to 16 to 18, you will get bail. Getting bail as a juvenile is easier. So he gave the juvenility certificate to the court and he got bail. This was challenged in the session court and the session court took it, because once you get a bail from the juvenile court, you have to bring it to the session court. Session court upheld it. We went to high court. And in high court, we had seen that the certificate, what he had given, in the act, it is written the school certificate. What he had given the certificate from principal. If the principal satisfies that he is a minor and his date of birth is so, that will be not taken into consideration. That was challenged in the high court, and high court upheld that the date of birth, what was entered into the register, because in this case, he did not have a birth certificate, but the school certificate will be considered what is entered during the time of admission in the register. So that was taken, that police was instructed to bring that from that boy belonged to UP. The boy belonged to Bihar, so one of the remote village. The police was instructed to go to that village. They were instructed to get that certificate. The certificate that they took the photograph of the register where the boy, when he had gone to the school, he had entered the date of birth in that register. That admission register photograph was taken and placed before the High Court, and High Court cancelled the bail of the this accused. So the age is a very important factor, because if you are proving that you are a minor, you will get bail. Second, your conviction rate is also, or your punishment rate, penal provision is also very low. It's maximum 3 years. It's in that, and you can't get life imprisonment in case if you are a minor, or you can't in POCSO. Even the act talks about having in aggravated sexual assault cases death penalty and life imprisonment. But if you are minor, you will not be awarded those. So people try to take advantage of those small things which are there in the law. And if a victim is a minor, of course, with trafficking, POCSO will be there. And if she's a major, then this section of IPC, sexual assault section of IPC 357, 376, and all that will be added. So that part is very important. Another challenge what we have seen in trafficking case is delay in FIR. Does delay in FIR hampers the case? if a girl has been trafficked for a year, 1 year, 2 year back, and she was sexually also exploited and all this thing, and she had not registered the complaint, but today she wants to come and register the complaint, can she do that?
I can see Vivekanandji nodding his head. He's saying yes. He's saying yes.
Yes, there are Supreme Court judgments. We say the delay in FIR will, lodging in FIR will not hamper the case. We have to go by the statement of the child. We have to still go by the statement of the victim. And because trafficking and sexual abuse are such things where a lot of taboo and other things are attached, and you really need a lot of guts to come forward and depose before the court. So delay in FIR will not affect the proceeding. The other thing with the judiciary needs to keep in mind about the procedure that needs to be followed by taking the evidence. They have to give them of course, once POXO is attached, so of course POXO provisions has to follow child-friendly atmosphere, no direct questions, and the defense counsel cannot ask directly to the child. The defense counsel has to write and give it to the judge. The judge has to then decide whether this question to be asked or not. Then the judge will ask the question to the child, put forward the question to the child. So, and to give a child-friendly atmosphere, they should not, accused and the victim should be kept separate. They should not come face to face. So this is the procedure which is there in POXO. And when in case of child, it is clear. POXO is attached, so you're going to follow it. In case by chance if POXO is not attached, or and there's a victim who is not a minor, in that case, what procedure needs to be followed by the court?
Is miti bahasa Indonesia?
Sitapaji, can you repeat the question, please? Because there's a request in the chat box. Can you repeat the question?
Yes.
Who, me?
Yeah, please repeat the question.
I say, what I'm saying, there's a traffic, there's a victim who has been rescued from brothel, and she's not a minor. In that case, what good procedure shall follow in her case for recording of her statement? Recording during the trial.
So the question is, if the victim is not a child, then in that case, for an adult, what is the procedure for recording of the statement?
By the magistrate or by the police?
By the magistrate. Police obviously have to be a woman police and special police officer to deal with in a sensitive way. And the police cannot force that girl to come to police station to record the statement. Police, if the girl is not comfortable or the victim is not comfortable, the police can go down to her place wherever she is to take the statement. But I'm talking about the court procedure. The magistrate, what procedure to follow?
Okay.
Under section 164, 5A CRPC.
164 also, as well as the trial. It is again the same thing. It has been upheld in Sakshi judgment, where it has to be a video conferencing thing in camera trial proceeding. If the victim is not comfortable coming to court, it can be done through video conferencing. Sensitive atmosphere has to be given. I would narrate a case over here in Delhi in the year 2007. I had rescued a girl, and she was a major. And Delhi police had done a lot to rescue this because there was a gang which was on for trafficking, used to get girls from Northeast, and this girl belonged to Northeast. So they put a trap and they caught the trafficker and they rescued the girls. The girl was supposed to depose, and the girl actually in 161 statement narrated everything. And there was also another minor girl who went to CWC also, and before the CWC also narrated everything. The trafficker name was Tiger, and then we went to court for her statement, and 164 statement went off well during the trial. And here was a judge who was a lady judge who was sitting, and during that trial, she's a good judge. She has given a lot of orders, which is on POXO and other cases, which were not, that time POXO was not there, but on child sexual abuse and rape cases, women cases. She just conviction mind judge. But in this case, when she went to the court, when this girl went to the court to depose, see, we need to understand they're also a human being. And that time, the sensitivity was a little less among the judges, and the courtroom was crowded, and she was standing there. And the judge asked her, "Theek hai, tum batao." When she was asked, she was told to narrate her thing. The prosecutor also asked us. She kept quiet for a few minutes. Then the judge got irritated by her attitude. See, we need to understand it. Even though they have been into this profession, they have been pushed into prostitutions and all that, they have been sexually exploited, but still for them to come out in the open world and talk about it, it takes a lot. They are also, end of the day, a human being. This girl was sexually abused 356 times. And the judge had everything before her. And so she said, do you recognize the accused? Tumko pehchanti ho? She kept quiet and all that. The judge made a statement. तुम सलवार खोल के बैठे तब कुछ नहीं होता, अभी यहाँ बोलने में तुम्हें प्रॉब्लम होता है. So like the sensitivity, like you generally, you in the brothel, you open your dress and you are with men, nothing happens. But here in the court, you don't want to speak. So that statement, that insensitivity of the judge, that statement actually put her off. She refused to give the statement. In spite of working police making such a good attempt, we lost that case because she refused to come before the court. And looking at her, the younger girl who we had rescued, who had given such a beautiful statement for the CWC, she also refused. She also backed out. So the sensitivity matters, like how we are dealing with the victim in the court. It is immaterial what is their background is. The fact is that they are standing before you, they are human being. We need to treat them with dignity. So the dignity is very important. After that, I mean, most of the time it is done through in-camera trial, and other media members are not allowed in cases of POXO and trafficking. But the fact is that the sensitivity is very important. How we talk, it's very important. How we are dealing with them is very important. That is why under ITPA we have this provision, and also under the CRP we have this provision that the judicial magistrate, by dealing with the cases of ITPA or dealing with the cases of trafficking, can appoint support person to counsel the girl, to talk to the girl, to give report to the court on, in POXO, what happens, support person is supposed to give report to CWC, but in trafficking ITPA cases, a support person can give report to the court. And if required, she's also someone to come and give the deposit for the court as a witness. So these are the small things that which we need to keep in mind. We need to be careful if we want to achieve conviction, if we want to convict the accused in the case. So one is sensitivity towards the victim, to maintain the dignity of the victim, irrespective of whichever background she belongs to give support to the victim. Judiciary should also think about rehabilitation of the victim. If this is ensured, and there should be victim witness protection. If those 5 things are there in place, you will definitely get conviction. And to do all this thing, we need to finish the trial on time. If you say, ma'am, Meghalaya has very few cases, I'm actually really surprised, because we have got a lot of girls from Meghalaya. We have rescued a lot of girls from Meghalaya who have been in massage parlors, who have been into brothels, who have been being child pornography and all that. They have been online sexual abuse. Maybe they're reporting the case in this area.
I'm saying reported because we got this data from the nodal from the Grants branch here in Meghalaya, but maybe because those rescued from there at the point of destination.
But ma'am, the law says because trafficking is such, it involves source, transit, as well as destination. So any point, anybody can make a complaint and rescue. And if we have AH2 placed in Meghalaya, now the AH2 needs to be vigilant. There needs to be there's also an action group which needs to be formulated to prevent trafficking. if girls and children from Meghalaya are coming to this side for commercial sexual exploitation are pushed into this profession, then the AHT needs to be very, very active. The vigilance committee over there needs to be very, very active. The Anganwadi workers needs to be very, very active, because they are the one who can share the information, and they are the first, because they go to everybody's house and they're supposed to take care of the children and babies for basic government implementation of government scheme. So the ASU needs to work with different department and prevent trafficking of girls and children from the state of Meghalaya, and prevent them from getting exploited. So it's very important that that is being done and that is being followed. And when we talk about forced labor, commercial exploitation is also a part of forced labor. I focused more on commercial exploitation and less on the child labor part, because the percentage of people coming from Meghalaya for child labor is very low compared to commercial sexual exploitation.
Okay.
I also want to ask one question.
Okay.
If a child is 2 years, because we have seen cases of child getting trafficked for adoption, trafficked for commercial exploitation, very young age, 3 years, 4 years, 2 years. If the child does of that age, if I give example of a child of 3 or 4 year girl, and that comes before the magistrate, the case comes before the magistrate that she was sold for adoption, and if you have to take a statement, do you necessarily need to go for an oath?
Jyoti, Miss Jyoti, please unmute Shri Noor Khan.
Yes, just a minute,
Hello, am I audible?
Yes, sir.
Yes, sir. Yes, sir.
Yeah. Am I audible, please?
Yes, you are audible, sir.
Yes. One, of course, she's put up a query about the child, a child of 3 years, 2 years coming for the 164. Well, of course, that's, of course, I think most of the officers, judicial officers, trying matters involving child. They're well aware that it's maybe question. Like ma'am was speaking about, when there is a dispute with regard to child. I have one question, is that when a child, when there's a dispute with regard to the child, whether the child is a juvenile or not, and this dispute is raised during the course of trial, because there's a lot of conflicting judgments of the various high courts. When this dispute is raised during the course of trial, that the child, because if the matter has been tried in a POXO court, and this dispute is raised before the POXO court, that the victim is not a child, because if that is decided during the course of trial, then the court loses jurisdiction. I just like to know that what is the view, because there's a lot of conflicting judgments from the different high courts. So I just want to know that how it's been dealt in Delhi or some big states, if you have any precedents on these matters.
So if you're talking about victim,
yes.
So when if a victim is not a child, and say while time.
I'm sorry. I'm so sorry, but I'd just like to clarify my question. Is that if the accused raises the question of the juvenility of the victim during the course of trial, that's a very important issue, because if the accused succeeds there, and the proceeding has to stop, the POXO court loses jurisdiction to try a matter. Because it can try a matter, only the victim is there. So because there are a lot of conflicting judgments on that matter.
So in that case, the fact is, when a POXO case is registered, the police, by doing the investigation, also has to take the certificate of the child. It's a birth certificate, or it can be school certificate, to prove that she's a child. And during the course of trial, if the police has not taken during the investigation, it's not part of 161st charge sheet, it's not part of a charge sheet. Then during the investigation, if this question raises, the court can definitely ask for document. And you are right, if the child happens to be not a child, then the special court loses this thing and it is being transferred to the regular court. But irrespective of that, the conviction, the trial will be decided, and if there's strong evidence of sexual assault, the conviction will take place either by the trial court or by the special court. The only difference is that the POCSO will not be applicable over here and it will go to the regular court. But the fact that this type of problem generally has to be, because while police dealing with the investigation certificate along with the, that's why I asked this question about the age thing. If the victim is a minor or a major, or the accused is a minor or major, accordingly the court's case will depend. So in case if anybody has a doubt, the police has to collect the evidence, where that is the certificate, and make it a part of the charge sheet, so that the case is strong right from the beginning itself. And in case
my query was
certificate is not there, in case birth certificate is also not there, school certificate is not there, no certificate is there, and bone ossification test, actually this case can come to a special court. If there is a bone ossification test, we say in the absence of other certificate, and the bone ossification test is never conclusive. The bone ossification test is always either 2 years plus or 2 years minus. In that case, what will happen? The benefit of doubt will go to the victim, and the court has to, and the matter will be tried in the POCSO court. It will go in the special court. And things that has happened also in Delhi. If you want, I'll share the judgment with you.
No, my question was on not during the course of investigation, but during the course of trial.
Yeah, during the course of trial also, if it comes out, if the accused raises a question about the juvenility, and that will happen only when there is an absence of documents, right? So the court can always order for a bone ossification test. And the bone ossification test is actually, it's not a conclusive test, because it will say 2 years plus or 2 years minus. If it is 2 years minus, then the benefit of doubt will go to the girl. But if it's 2 years plus, 2 years plus 2 years minus, the benefit of doubt will go to the victim. But if it comes that it is more than 20, if it is more than 20, it may be 22 or 18. In that case, the matter will go to the regular court.
No, ma'am, only just finally, maybe I just take half a minute. My question was that during the court trial, because JGB Act is very clear that that an accused can raise the question of juvenility at any stage, even after conviction. But then, when it comes to the victim, it has been interpreted by various high courts that the victims and so far as the question of juvenility is concerned, the victim to follow under the old Act, Section 7A, talks about an inquiry. But here I'm talking about the victim. There's no, I said that we have got conflicting judgments. When it comes to the accused, it is settled. They can raise this issue at any stage, even after conviction. But here I'm talking about the victim. And the juvenility of the victim has got a serious implication in trial.
The POCSO, what will happen, the benefit of thing will go to the victim, because the burden of proof lies on the accused. So even if he raises, and if the special court magistrate is of belief that the child is not a juvenile, because you have to satisfy the special court magistrate about the age of the victim. And if the special court magistrate is satisfied, even if the accused raises a question, it is the accused who has to prove his statement, not the victim. And the victim, and there's nothing wrong. I mean, he or she has a document, and the case will go on.
I'd just like to share.
Other cases, the burden of proof lies to prove that this incident has happened. But in POCSO, it is on the accused to prove that he has not done it. So it depends on the magistrate. If the magistrate is satisfied that case in the POXO Act Section 32, if the magistrate is satisfied that the child is a victim, juvenile, then or a minor, then the trial is on.
I just like to share my view on that matter. Is that POXO Act provides that it empowers the special court to convict a person in any other offense also.
Right.
So even if that question of penalty is raised, that is not to be decided at the conclusion of the trial. At the most, if the victim is found to be not, if the victim is not a juvenile, still the accused can be convicted under the Indian Penal Code. The only rider which has been imposed under the POXO Act is that whichever the punishment is greater, POXO Court does not loses the jurisdiction to try an offence under the IPC. But the only rider is that whichever the punishment is greater. So this question is not to be decided, not taken out and decided during the course of trial, like the way we decide for the accused. Because the question of juvenility has to be decided first for the accused. But when it comes to the
So
victim,
one must understand the principle of having a POXO Act. The principle of having POXO Act talks about it's a victim-centric act. So therefore, the special magistrate can decide the offences under POXO even if there is a case on even if the accused raises the question on juvenility. And this is a case, POXO Act is an act where the onus of burden of proof is on the accused, not on the victim, sir. Normally in other case, it is other way around. But in POXO, it is on the accused victim. And even if the accused raises this question on the juvenility of the thing, and if the special court is satisfied, the special court can give order, there is nothing wrong in it.
thank you. Thank you.
Okay. Ms. Sampurna, before we give the chance to you've asked a question as to whether the oath will be taken or not on the victim, right? As usual practice, I used to see magistrates used to administer oath for recording statement under section 164 only above 12 years, for those victims above 12 years. But below 12 years, they don't administer oath.
Ma'am, it is all depends to magistrate. And but yes, if the girl is very small and the magistrate feels he doesn't understand the meaning of oath or doesn't understand the consequences of taking an oath, and she's speaking the truth, in that case, the magistrate has the authority for not asking the girl to take the oath. But in doing that, the magistrate has to cite a reason, because this has been taken up in, this has been challenged in POXO cases. The cases that the girl has not deposed by taking oath, and so whatever she has said is not genuine. There's no truth in what she has said. And the high courts have also, there are some high court which has taken up this, but it has gone to Supreme Court, and Supreme Court has upheld that if a child is not in a position to understand the meaning of oath, and her statement is truth, and the magistrate is satisfied, the magistrate only has to give a reason. And in this case, the punishment was upheld for the accused, and conviction was taken place. So if the child, but the magistrate has to raise a reason why he has not asked the child to take the oath. That reason has to be specified. But I would request victim compensation to be taken more seriously, because this is one area where compensation is must. Okay. And Supreme Court has again and again have said. Yes.
Hello. Hang tu. Hang me. Teman tabu kari.
Okay. Are there any more questions? Otherwise, we have already. You want to say something?
Yes, ma'am. I would like to ask one question regarding juvenility proof of the accused. Suppose if, because we have to take the certificate, right, about the birth, I mean the age. But what if from the physical appearance, he appears to be older, but the certificate is still a minor. Can the court send for ossification test?
No, if the birth certificate has been issued by the municipal corporation or any relevant authority, the court cannot ask for ossification test. Because ossification test is also very, you are exposing a child to X-rays, I mean, it's ozone rays. So it is harmful for the body. The ossification test, one should go when there is absence of this two document, school certificate or the birth certificate.
Can I also add something here? The Juvenile Justice Act, ma'am, says that from the appearance, if a person looks like a child, then the proceedings can be taken up, assuming that the person is a child. But from the appearance, it doesn't mean that, it can be a conclusion that the person looks like an adult. So the conclusion can only be if a person appears to be a child. The other way around cannot be concluded from the appearance as per the Juvenile Justice Act. It says very clearly, if the person looks like a child, then the JJB or the CWC can proceed, assuming that the person is a child. And if from appearance there is a doubt, then the procedure of getting the documents need to be followed. So the appearance relates only if the person is looking like a child. The appearance does not apply if the person looks like an adult. Are there any other questions? Okay. Question, ma'am, if the accused provides the school ID to prove that he is a juvenile, whether he'll be considered as a juvenile?
That depends on what school ID he is providing. If he's providing school ID or school certificate.
School ID. School
ID is not, ID will not be considered, but school certificate definitely will be considered for declaring him to be juvenile. But ID is not. ID is not a relevant section. And in the trial, there are many judgments which affirms that the provision mentioned in the JJ Act, section 92, for the age, one has to refer that. It has to go as per that. So in that, there is no mention of school ID. It only talks about school certificate. In fact, this has been changed in 2015. Earlier, it used to be first school certificate. Now, school certificate. School pass out or school transfer certificate or the registration certificate, any school certificate. ID will not do. ID is again registered by the principal, signed by the principal. No, so ID will not do.
What if there is a suspicion that the school certificate is issued by headmaster of dubious character?
School certificate depends on the dubious character. So the certificate issued by headmaster will not be considered. That is what I cited this case, State versus Manoj Shah versus State of Delhi and NCT, where the accused gave a certificate certified by the principal. School certificate given by the principal. The principal cannot certify. It is the time of admission, what you have enrolled in the register, that certification will come. A principal cannot certify. And if it's a dubious character, so the court will not come to know whether it's a dubious character or not, but court will not accept the certificate issued by the principal. Court will only accept what is there in the register at the time of admission.
As because Ms. Aparna, what happened is that most of the interior parts of Meghalaya, like most of the people, they don't register their birth. So what happened at times, it could happen also that they can buy school certificate. So can the court do inquiry, ask for the register from the school?
Yes, they can do. Yes, that one. There is also other provision in case in the absence of birth certificate, in absence of school certificate, and the born ossification test is not conclusive, then what one can do, court has actually have taken two routes. One, they call the medical board to certify. Most of the time, because the principal, they go by the principle of JJ Act, so the benefit of doubt goes to the victim or the accused whose certificate is given. Other thing they do is they even the panchayat of that village, they have also certified the ages. Like the view of the panchayat regarding the age can also be taken into consideration, and in balance with the bone ossification test, the age can be considered. The important thing with the police needs to keep in mind is while doing investigation, the forensic investigation is always lagged. You do all the physical investigation, collect sample, take statement and all that. But what the lapse happens, most of the time I have seen the trial get defeated when the forensic report comes. It says that it's expired. The samples have expired. Reason is we don't collect the sample properly, we don't sell it properly, we don't send it to the FSLA lab on time. There is no point in collecting the samples and not sending it on a time. And many times what we have seen, the samples are like undergarments, but commercial sexual exploitation, we have to be 100% careful because different types of sexual acts happen. There's a swab from mouth, swab from ears, hair, back part of the body, right part of the, all the swab needs to be collected and sent to the forensic lab. And there is also a consent of forensic interview. When the child or the victim who has been rescued, to ensure to get the maximum truth out of the thing, then the engagement of a psychiatrist or forensic psychiatrist is very important. And the forensic interview is permissible under the law. And then in that cases, if you are involving a forensic psychologist or psychiatrist over here, the chances of truth will be higher than the statement what recorded by the police or the magistrate will of facts. So the forensic interview is also very important, and sending the samples, collecting swabs from different parts of the body. And in brothel, so one has to take everything and send it to the FSL lab but on time. It has to be properly sealed and on time. There is no point sending it after 48 hours. There is no point sending it after 1 week to the FSL lab, because you will not receive the result that you desire to receive. The other thing is that to set up FSL lab in the all major city, one of the reasons why there is a delay because FSL lab are very far away situated. In one of the direction of Supreme Court has asked the state to set up FSL lab. In fact, also allocated funds for it in different parts of the country. So if SLSA, I could request SLSA to take up with the state government and can facilitate this setting of an FSL lab in the taking the Supreme Court judgment and establishment of FSL lab and main city, so that the samples are sent on time and you receive the result. The other thing is like many a times so happens, the police also tries to speak to the victim, and many times they come to the court to say that the charge sheet cannot be filed because there were many accused, but we have not taken the statement of all the accused. Not necessary. If the child says or the sex worker or the victim who has been rescued says that there were customers, not necessarily that you have to take the interview of all the customers. One customer is more than enough to prove that the case was running there. And in fact, in the Gaurav Jain case, this was defined over there. And and the court had upheld that it's not necessary that you need to interview all the accused or all the customers who were there to prove that it was a brothel. The fact that the girl was brought there for commercial sexual exploitation for sexual activity, that itself is enough proof to prove that the place is a brothel. So you don't have to really go hampering around. If ek aadmi mila, baki nahi mila, to ye brothel nahi hai, that will not work. In Gaurav Jain, it was upheld by the court, and the court has clearly defined this.